you, Tony. My name is Teresa Phillips. I'm here today with my colleague and partner, Eric Boughman. We're here at Forster Boughman, coming to you with our seminar today, What All Medical Professionals Should Know About Florida's New Elderly Exploitation Laws. If you haven't joined us before for one of our seminars, I primarily practice in fiduciary litigation and fiduciary administration. And Eric, would you like to tell them what you do?
Sure. Good afternoon, everybody. My practice primarily involves representation of individuals in healthcare and medical professions, and both transactional and related litigation for healthcare. I also deal with some business issues and technology issues, oftentimes that touch the healthcare industry. And this seminar today, I appreciate that Teresa was on top of this statute, put together the materials and the idea for this seminar today. It is a nice tie-in between the two practices where we primarily spend our time, and hopefully you'll learn something good today.
I agree. So let's look at the agenda and see what we're going to be going over. The first part is going to be breaking down the newly revised section 415.1034 Florida statutes. This is a section of the law that deals with a requirement to report vulnerable adults, which usually includes the elderly, who you suspect or have reason to believe are being exploited, whether that be financially or physically or otherwise being abused. We'll then take a look at what are the protections for those who do report. And then 3, look at legal consequences for failing to comply and to report. We'll look at a section and have more of a discussion about what we would advise health professionals to do to ensure their compliance and to adhere to any duty that this section provides to them now. And then we're probably going to wrap up with talking about some trends in this area, which seems to be expanding here in Florida, and conclude with some questions.
And we also welcome you, if you do have a question during the course of this webinar, to type it into the question box. It's available through the GoToWebinar interface. Or if for some reason you have a question that comes up after the webinar that we don't address directly, or if you think of something later, you're always welcome to reach out to Teresa or myself.
Thank you. So let's just dive right into it. Let's look at what, before we look at the statute, let's look at some definitions. I think they'll help you understand what's going on here, and they're kind of important to know so that you know what kind of people you should be looking out for. The definition of a vulnerable adult is defined in section 825.101, subsection 10 of the Florida statutes. It means a person 18 years of age or older whose ability to perform the normal activities of daily living or to provide for his or her own care or protection is impaired due to mental, emotional, sensory, long-term physical, or developmental disability or dysfunction, or brain damage, or the infirmities of aging. I'll tell you, Eric, sometimes I think people are surprised to see how broad that definition is. You're talking about anyone who can be above the age of 18 that has some kind of impairment or something that keeps them from functioning at the same level as your average adult. So it's not just that 90-year-old person that maybe sometimes comes to mind when we talk about these kind of statutes. What's abuse, neglect, or exploitation of a vulnerable adult? Exploitation focuses on persons exploiting the elderly or disabled, either financially or otherwise taking advantage of a position of confidence or trust.
And of course, here in Florida, because we have a high retiree population and a higher elderly population, we do often see this in the context of our elderly population, but as Teresa points out, it could be others as well.
And unfortunately, elderly exploitation seems to be on the rise, probably leading to why we're getting new laws on the books. So let's look further at our definitions here. I want to point out what a position of trust and confidence is, because primarily the people that may be watching this seminar, or people or your clients who may be affected by this law, i.e. medical professionals, these may be the people they actually deal with more so than the patient. So a position of trust and confidence is a person with respect to an elderly or disabled adult, means people who are either a parent, spouse, adult child, or other relative by blood of marriage of the elderly person or adult, essentially any relative. is a person that's a joint tenant or tenant in common with the elderly person or disabled adult. That means they own some kind of property jointly. They have or they could have a legal or fiduciary relationship with the elderly person or disabled adult. These are things like court-appointed guardians, trustees, powers of attorneys in facts, attorney in facts appointed under a durable power of attorneys. Even a healthcare circuit, I think, would fall under someone who has a fiduciary relationship. And those are oftentimes the people that medical professionals are actually coming in contact, not just their clients. It can be the caregiver of the elderly person or disabled adult, and it's also any person who has been entrusted with or has assumed responsibilities for the use or management of the elderly person or disabled adult's funds, assets, or property. So, so exploitation oftentimes comes from those people into the position of trust and confidence, and the law imposes a little bit higher duty on them as to how they deal with the people that's entrusted them.
So, Teresa, would you say that there is a certain age at which folks who serve the population need to be on alert, like the healthcare folks we're talking about today? Once folks, if you're dealing with somebody who's 65 or older, does the law speak to a particular age where somebody is more likely than not to be considered a vulnerable adult, notwithstanding any other infirmities they may have?
Age is certainly something they take into account, and there's nothing that's been set forth specifically in the broad definition of vulnerable adult. Some of our more specific statutes that deal with exploitation deals with certain things like giving them rights for speedy trial. That age tends to be 60, tends to be that they look at under or over. That seems to give a presumption that you may be dealing with someone who's being exploited.
So if that's the case, I would suggest then for the folks that I advise that for anybody that you're dealing with who's over 60, you may want to be on extra high alert with respect to the issues that we're going to talk about today.
Good advice. All right, let's move down to the next slide here. Mandatory reporting. So that's what the statute's about, and it's just recently been revised as of July of 2020 to take effect, and it's actually added parties that are mandatory reporters now. And in addition to adding those parties, it's firmed up on what some of the relief is available to someone who's a victim of elderly exploitation. But for the purposes that we're focusing on today, let's look and see how this affects those involved in the medical group. So here's what 415.1034 Florida statute says. Any person, including but not limited to any physician, osteopathic physician, medical examiner, chiropractic physician, nurse, paramedic, emergency medical technician, or hospital personnel engaged in the admission, examination, care, or treatment of vulnerable adults. Next section, health professionals or mental health professional other than one listed in subparagraph 1 here above. A practitioner who relies solely on spiritual means for healing, nursing home staff, assisted living facility staff, adult daycare center staff, adult family care home staff, social worker, or other professional adult care, whether it's residential or institutional staff. If you haven't noticed by now, I think we've covered almost anybody that could be in any way remotely involved in the medical profession. It goes on also to include certain state employees, employees of the Department of Business and Professional Regulation, and members of the Florida Advocacy Council of Disability Rights, Florida members, and also bank and savings and loans employees, credit union officers, trustees, and employees. But I think you can see from that list, there is definitely an intent to cast a wide net to grab anybody who might be seeing someone or be exposed to someone in the medical field to report. So we've got it now. We got our players who are affected. Let's see what they have to do. I've got it here in bold. These people who know, if they know or have reasonable cause to suspect that a vulnerable adult has been or is being abused, neglected, or exploited, shall immediately report such knowledge or suspicion to the Central Abuse Hotline. Notice the word shall.
And so that's a mandatory requirement for reporting. And when the statute was amended, I'm jumping back here to the slide, but they took time to list out several different medical professionals, and then to the extent that there's any doubt at all, here in the second bullet, include all health or mental health professionals other than those listed in subparagraph 1. So that's essentially if you are working, or if you think you're working in the healthcare industry or any of these other areas, then you have that mandatory reporting requirement.
Yeah, they even went on to list the office staff essentially who are dealing with admissions and things of that sort. So it's pretty broad.
Broad duty to be on alert, and that doesn't mean that you close your eyes to this. You have an affirmative requirement to report, and when you report, the information you need to include in the report. You want to cover that?
Yes, it seems a little long, but I think it's information that most people involved in the medical profession would have already. But let's look. To the extent possible, your report should include the following: their name, the age, race, sex, physical description, and location of each victim that you're alleging that was abused, neglected, or exploited. That makes sense. They need to be able to identify this person. Then number 2, so they can contact them: their names, addresses, and telephone numbers of the victim's family members. The names, addresses, and telephone number of the alleged perpetrator. The name, addresses, and telephone number of the caregiver of the victim if different from the alleged perpetrator. The name, addresses, and telephone number of the person reporting the alleged abuse, neglect, or exploitation. Description of the physical or psychological injury sustained. Actions taken by the person who's reporting, if any, such as did you notify the criminal justice agency, i.e. your local police. And finally, any other information available to you which may establish the cause of the abuse, neglect, or exploitation that occurred or is occurring. And I'm put the number there for the abuse hotline. We're going to give you that information at the end too, because you can report by phone or online as well.
I saw that recently on, I think, a bus. So we're seeing that around town. Florida is spending time and money to circulate this information to look out for our vulnerable population. So you want me to field this one?
Yes, let's tell people now what the protections are, if any, for those who report.
So when one concern that always comes up when someone's considering whether to report this information is, well, I don't want to get involved. Right? That's really the basic issue. I don't want to get involved. I don't want to get myself in trouble. I don't want to be drugged into the middle. And so what we want to see from a legal perspective to protect the folks who have a requirement, a duty to report, is immunity. And the statute offers what they call in the statute absolute immunity. That's the language in the statute. Absolute immunity from liability when acting in good faith. So we call this sort of really, we have 2 forms of immunity in Florida. And immunity essentially means that you can't be sued for your actions. You can't be dragged into a civil lawsuit, criminal lawsuit. You can't lose your job. You can't have any repercussions taken against you based on fulfilling your legal requirements. A qualified immunity is, as it sounds, one that does not apply all the time, but you have to satisfy certain circumstances in order to have a qualified immunity. And absolute immunity is just like it sounds. You have an absolute immunity. When a lawyer files a lawsuit, for instance, the lawyer representing a client, although the lawyer can still be sanctioned and have other repercussions for a frivolous lawsuit, the lawyer enjoys absolute immunity from being sued by parties just for the basis of filing the lawsuit. Otherwise, people would be afraid to file lawsuits. So here we have an immunity. It's qualified, but it's really only qualified by this good faith requirement. At first, I don't like that language in the statute, because now we're saying, okay, now you have to meet a certain standard. But the statute gives us some more clarity and essentially says that good faith is presumed unless clear and convincing evidence to the contrary is presented to show that there was not good faith. And clear and convincing evidence has a legal connotation to it. It's a higher standard. We have different burdens of proof when we talk about legal proof, and we have essentially we go from a balance, which is just a oh my gosh, help me with the term, please. A fundamental balance of evidence, which is your
more or less 51%.
51%, and then you have clear and convincing standard. You have beyond reasonable doubt. That's the standard for criminal cases, and here it's a pretty high standard. You'd have to show that somebody was not acting in good faith. What this prevents is somebody who's got an axe to grind of making a report. Let's just say that you have a health professional who is not the trustee of dad's estate, but the sister is, and reports that they think that the sister is abusing dad, and they're really only doing that because they want to step first in line. That's the type of thing that can get you in trouble. But otherwise, it's pretty strong. There's really no reason, if you have a good faith belief that there's something to report, then you report it. And as we'll see, there's also confidentiality that attaches, so you're not going to get drug into the middle of this. And then they felt the need, and I'm not quite sure why here, I guess we're in Florida, to add language that says that, by the way, you don't get that same immunity if you're participating in the abuse. So,
Yes.
you know, it seems a little, it's pretty obvious, but to the extent that it's not obvious, that language is in the statute. So as long as you have a reasonable belief, if you think that something's going on, then you are required to report it. And whenever you're fulfilling a legal requirement, you're generally, especially with the language they've included here in the statute, you're really on solid ground. So you shouldn't have any worries if you have a good faith belief that something might be going, not that it is, you don't need firm evidence, but if you suspect something's happening, if you suspect there could be abuse in the background, then call the number or go on the, we'll give you the web information at the end, go on, make the report. The report's going to be confidential. So I'll continue here with the protections that we have, both confidentiality of the reports and the reporter, the person making the report of the information. Your identity is kept confidential. The only way that identity is shared with anybody would be through certain government agencies and subpoenas, but even though Florida has a broad public records law and our sunshine law allows for disclosure of a lot of information, if you report potential abuse or what you think might be abuse, your information is going to stay confidential and not be released to the person that you report against. And generally the reports are confidential. Again, there's some exceptions and some carve-outs for the reports themselves, but generally speaking, that information is going to be confidential as well. So you're protected. The point here is that there shouldn't be any hang-ups for anybody who's wondering whether or not they see something they think it should be reported. You should most certainly do it, because you have legal liability if you don't, and we'll talk about that a little bit further down in the slide. This is akin to a whistleblower type protection with the broad coverage of who has requirements to make a report of potential abuse. If you work for a healthcare facility, long-term care facility, something of that nature, and you make a report, you are protected from any adverse action from your employer. So you can't be fired, you can't be disciplined or receive any anything. Nothing bad can happen to you if you're the employee of a facility and you report. If you're an employee of a hospital and you think something's going on, any type of circumstances where, again, where anything, what they've done with these statutes is try to take away any hindrance that would prevent somebody from making a report when they think something's going on. They want to know about it. And in fact, one step further, not only are you protected from adverse action, but if you do make a report and your employer takes adverse action against you, that will justify a cause of action, a claim in a lawsuit, and you can sue your employer for taking adverse action against you. Let's see if we have any questions. Nothing yet, but we're going to get a little bit of hypothetical issues here. So let's talk about confidentiality. Where this may come up is some folks might say, and this has happened in similar cases where you want to report the issue, but you say, look, I'm limited in what I can report because my relationship, either through the physician-patient relationship or due to medical records laws or something similar, that what I deal with is confidential, and so I'm not at liberty to share this information. Well, that is not going to work, and we'll talk about a case a little bit later where someone raised that as a defense when they were actually sued for not reporting something similar in an analogous circumstance. Here we have the primary privacy laws that affect healthcare professionals here in Florida are our state law, which is the Florida Medical Records Law. It's section 456.057. And there is a specific carve out in that statute that provides for disclosure to protect a vulnerable adult. And so you're protected under state law, and also under federal law, there is under the HIPAA privacy rule, there's an exception that exists as well for reporting this type of information. And the categories of exceptions, at least one of these, and really a couple cover the circumstances here. If the report is required by law, which in our case here with the new statutory amendment, the report is required by law, so you would be covered there. And also, if you're reporting abuse, then there's a carve out in the HIPAA privacy rule for that as well. And of course, if you think that there's a chance there could be serious harm to individuals, then you have a reporting requirement as well. So no issues you can't raise as a defense to failure to report. If there's confidentiality issues, you don't have any concerns. You still need to take reasonable steps to otherwise protect confidentiality of information. But as far as a situation where you're going to face liability for sharing information that you report on a vulnerable adult, that's just not an issue. So between the immunities and the protections and the confidentiality carve-outs, again, they've really covered all bases with this law to remove any obstacles to reporting, and also to prevent any situation where somebody thinks that now they can get out of their duty to report because there's some other counterbalancing issue in law. All right, so who's going to find out? I mentioned earlier that there is you have immunity, you have confidentiality, but the next question is, what about the individual themselves? Will they find out if I report the issue? And here's limited circumstances where notice to the vulnerable adult may be required. Typically, no notice will be required if you believe that informing the individual will place them at risk of serious harm, or if by reporting information to a personal representative, you would be actually talking to the person who is maybe involved, complicit in, or somehow involved in the abuse. So there may be certain requirements where you have a duty to disclose information to the individual themselves, but when you look at the strict language of the statute, what the statute requires, the statute doesn't require a report to the individual or to the individual's caretaker. A statute requires reporting to DCF, and either by the hotline or by filling out the form.
I just want to make a note there because I know it said personal representative. I think, and as the term is used there, what they're looking at are personal representatives, people that may be representing the actual patient or the person, individual, and if you inform them, that you'll essentially be informing the abuser. I don't think it means personal representative that us fiduciary people know as the representative of someone in their estate.
That's a good point.
All right, now we're getting into section 3. We're moving right along. Legal consequences for failing to comply. We're going to point out some civil, criminal, and some ethical potential consequences that we think everybody should be considering. And I'll take on the civil ones. And the civil is pretty simple, or has been simple, it seems like, in the past. The law had routinely been, when someone would try to sue under this provision, saying someone had a duty to report and they didn't, the court would come back and say, well, there's nothing in the statute that says you get a civil remedy. So, dismiss the lawsuit. And that was pretty consistent until 2015, at least here in our local jurisdictions of Florida in this area. There was a case that came out that I think is rather significant, and folks who follow this area of law think it's significant too. It was a decision on actually a motion to dismiss. So it's not an appellate case or something like that with those kind of attachments to it, but it had some significant language in it. And I welcome you to look it up yourself and read it if you're a legal nerd like we are. But what was telling about this is that the attorney involved with the plaintiff and the judge did an interesting turn on that old law that there's no civil remedy under the statute. And what happened, the judge denied the motion to dismiss, even though they had sued under the statute, because even though he denied the count that was specifically under the statute, he knew the plaintiff also had a count for negligence. And the court reasoned like this: if you have a duty under the statute to report, and the common law under negligence is that a breach of a duty can form the basis of negligence, even though you don't have an independent civil action, you can certainly have an action for negligence. if he failed to report. And the court noted that under any circumstances where a professional or person that third party that was involved with the vulnerable adult or the exploited adult was in a position to recognize and ascertain abuse and therefore could have reported it and maybe stopped the abuse or mitigated the abuse, that that the law does impose such a duty, and if you breach it, that it can be a foundation for a negligence claim. Now, the case didn't go much further than that. It ended up settling shortly thereafter, so we don't know what would have happened. But I think that language is significant, and I think you'll see more practitioners using that logic, that legal argument that was articulated by the federal judge there, that, okay, it doesn't give you an independent right to sue if someone fails to report, but maybe that's a basis for negligence. Which is just as significant because it means you'll be responsible for any damages flowing from your negligence.
And I think we see that in some other jurisdictions. We see places like California and other states where they have had the cases go further. And the procedural background of that case and the fact that this was at the motion to dismiss level, while it doesn't mean a whole lot to the average person reading the case, but from a practical perspective, what happens is when you're trying a new theory of law, you bring a claim, and if there's, as there was in this case, there was no explicit language in the statute that supports your claim, the other side will file, the defense will file a motion to dismiss, and the legal standard for that is, assuming all facts to be true, have you stated a cause of action for which the law provides a remedy? So if you go on that standard, that you assume everything is true. So assuming that whatever was alleged is the factual allegations, the circumstances of the failure to report in this Ginder case, the judge says, hey, if everything you've put in the complaint here, if this is all true and you can prove this by the end of the case, you've got a claim. And so that makes folks on the defense side very nervous, because once you file that motion to dismiss, if you kick this case, now everybody would be citing this case to say, look, there's just no cause of action. You have a federal judge says there's no cause of action, you can't do it. But now you've got a judge who allowed the case to go forward, and more likely than not here, there was a monetary settlement, I'm betting, some type of settlement where which often happens. The parties agreed to a settlement, so it doesn't get reported as an appellate decision. But I tend to agree that I think we're going to see, especially because of what we've seen in other jurisdictions.
Yeah. And if you imagine what's going on with these cases with elderly exploitation, obviously if you catch the abuser, the money's able to be returned or transfers undone, otherwise the person's made whole, then the third party who didn't report, who cares so much? But in a lot of these cases, these people are left, destitute. They're going to be burdens of the state. These people have exploited them, and it's gone on for a while, and they've left the country, or they've wasted the assets, and you can't undo that. And now especially plaintiffs' counsels are looking to third parties, and in the past and one of the third parties that can be involved are the people that had a duty to report. And in the past, everybody's just stuck with that. Well, there's no civil remedy. I'm not so sure now after that Ginder case. I think negligence might make a basis for a breach of duty if you don't report.
And the bank is a good defendant, but they're a good defendant from a financial aspect. But wasn't that case, didn't that have to do with somebody coming in with a vulnerable adult?
They did. The bank actually had red flagged themselves that it looked suspicious what was going on internally, but then noted that their internal notations suspected fraud or exploitation, but they didn't report it. So
now let's put our legal hat on and try and take a look at this from a plaintiff's perspective. If you want to make this case, you're talking about maybe a bank teller or somebody at the bank and their duty to report what they think is suspicious activity that would be a circumstance of abuse that could harm the vulnerable adult. Now take that same scenario, except put it in the context of a healthcare provider. How much higher duty does a healthcare provider have to see to the wellness and the proper treatment of a vulnerable adult vis-a-vis a bank teller? Mm-hmm. So I think that because the standard is higher, if you're a physician or in a position where you're providing for health and medical treatment for a vulnerable adult, and you don't report this, We don't see bank tellers, for instance, being sued for malpractice, for a breach of a duty. We don't see banks being sued for malpractice, for breach of a duty, but we certainly see healthcare providers all the time being sued for malpractice because your breach of a duty lend itself to further harm of the individual. And that's why I think it's even probably now with the amendment of the statute, somebody's going to take a shot at this. And it remains to be seen whether or not they'll have any success, but please be on the alert for it.
Sure. And I think it ties into our whole the whole purpose of our seminar today and the discussion we're having here. There's definitely a trend going on. The statute that we cited to, it's not new per se. It's that it's being expanded, and it's been expanded a couple times already. Other statutes are being expanded, and now that's related to exploitation and abuse. And now we have this principle of law being floated out there. So I think there's a potential for civil liability to really become more of an issue than it has ever been when it comes to not reporting. So something to be aware of, to be on the cusp, and hopefully make it your goal, either you as a practitioner or you as an attorney who represents a practitioner, not to be the one that's on the test case as the defendant.
That's it. So other potential liabilities?
Well, there's always been criminal, so here, this is what the statute says. A person who knowingly and willfully fails to report a case of known or suspected abuse, neglect, or exploitation of a vulnerable adult, or who knowingly and willfully prevents another person from doing so, commits a misdemeanor of the second degree. A person who knowingly and willfully shall make or file false reports to the APS, that's Adult Protective Services, or law enforcement agencies, or advises another to do the same, commits a felony of the third degree. And a person who acts in good faith in making a report is immune from prosecution. I think there's a few interesting things there. I think probably those in the medical field and most fields, seeing physical abuse is different than financial exploitation. Those signs are probably a little bit more clear, and I think it's everybody's instinct to probably report that. But financial exploitation of a vulnerable adult, even though that's, there's a duty to report that, and there can be criminal consequences, I'm sure there's practitioners out there and people who fall under that wide net that we looked at earlier who think, well, how am I supposed to recognize exploitation of a vulnerable adult? How do I know they're financially being exploited or taken advantage of and things like that? So those are some things that we're going to delve into some more, but just recognize that the criminal penalties arise not just if you don't report physical abuse, but also if you don't report financial exploitation.
And I think what we're also seeing here with the language in the statutes here is there's a penalty for not reporting. There's also a very stiff penalty for making a false report. And again, we see this immunity language, both from civil action and from prosecution, now in a couple different areas of this chapter. So protections for people to make the report. And really, I think what the law is trying to do and what the legislature, the message that they are sending is the public policy of the state, which is reflected in our laws, wants professionals to report this information. And there is now, you have language that supports both a criminal action for not reporting, but when you do so, you have to do so in good faith. And there's also a very stiff potential penalties if you do make a report in bad faith.
I think it's even more than bad faith because it says knowingly and willfully. So that's even to me hard. I mean, that's a really high standard. That means you have to know it's false and you're moving forward with knowing it's false.
Anyway, so back to my example of the professional who's got a relative who's in a position to take care of dad or someone else and doesn't like what's going on, so then makes a false report, and you knowingly make that report, you get yourself in trouble. But otherwise, if you're acting in good faith, you're protected. But if you don't act, you've now got criminal liability. And again, I think what people should take away from this is there is at least a potential for civil liability, although it remains to be seen, when that case comes along, what will happen. But if there is civil liability and you get sued, you can certainly rest assured that in that lawsuit, we are going to see claims for punitive damages.
Yeah, this was another point on that area of negligence. If the duty to report, if you have that duty, you fail to report, and it forms the basis of negligence, can it become so so gross that punitives are involved, and punitives can be very significant. They're meant to punish you. They're meant to hurt even, and it's much more than what the actual damages are in most cases. So when do you get punitive damages? There's two examples. Intentional misconduct. It's probably going to be rare in a medical setting, I'm guessing, that somebody would intentionally not report, just they know and they don't want to report because they want to cause injury. That's probably not usual. Probably the more likely examples maybe is going to fall under a fact scenario that could be called gross negligence, where it's so much to get involved. It's not something they want to do, and they have an indifference to what's happening. Not that they want it to happen, but that they're just indifferent to what's going on.
I could certainly see a gross negligence case arising out of circumstances where, take the bank case, the Ginder case, and put that same fact scenario in a healthcare environment where the vulnerable adult was in the care of a medical provider, and there was documentation in a record that there was suspicion that there was something going on, but it wasn't reported, or there was talk, or there was some indication that the provider knew or had suspicions or reason to know that something was going on, failed to report it, and the vulnerable adult, is injured or suffers either a physical injury or some type of financial injury. But here, I think in the healthcare context, we're talking about potential physical injuries. And if that's not reported, then not only are you going to be looking at a negligence claim, but potentially a negligence claim with a claim for punitive damages.
And I can't imagine anything that's more likely to enrage a trier of fact, especially a jury, more than letting a vulnerable adult be abused or further exploited to the point to where they can't even financially take care of themselves and they're a ward of the state.
Here's just a couple more notes on punitive damages. Vicarious liability. If you have an employee and the employee doesn't report and the employer is complicit in that in some way, the employer can be held liable both for the negligence and for the punitive damages arising from the misconduct of their employee. Any officers, directors, managers, anybody who knowingly, not only, it doesn't mean that you have to necessarily, that the company higher-ups have to participate in the bad conduct. They just have to know about it and look the other way. And you're facing potential punitive damages at the company level and at the individual professional level. And then also ethical duties. So for healthcare providers, you have an ethical duty to care for others. That's what it comes down to. And so again, with our most vulnerable population, the failure to do so potentially exposes you to not only an ethical breach, but the attendant professional complaints and issues that could come with that breach of that ethical duty.
And the publicity could have really major consequences, no doubt. So I think you've put some case examples up for us here next, so that we can actually start looking at how do we everyday situations that might come up.
Okay.
How is this kind of working itself out?
So here's a case. This is a live case. We put a little bit of a spin on it because we wanted to be able to use it for the seminar. But this is certainly a case that happened with a few factual. We took some factual liberties with the case to put it in our situation here because the statute's relatively new. We had a circumstance of a physician who was serving as an emergency room doctor when a vulnerable adult came into the ER with a fracture in her lower leg, and the fracture had given the appearance, according to the records and according to the doctor, of being twisted by human force. So it looked like abuse. And so the doctor suspected that abuse had occurred, but did not make a report, and it was noted in the record. So that was, and by the way, was later asked, and the doctor didn't deny that there was a suspicion. There's a state law in place that required the physician to report suspected incidents of abuse to police. But here, the physician relied on the confidentiality argument. That's what I alluded to earlier. Physician said, well, I couldn't report the injury to the patient without violating the doctor-patient privilege, and there's requirements with medical records. And so, yes, I suspected something, but because of counterbalancing legal requirements, I couldn't report or disclose that information. The vulnerable adult was treated for the leg fracture as an accidental fracture, not intentional conduct, was released to the caretakers, and the caretakers continued to abuse her regularly until she suffered a severe permanent injury. And so the question for our audience here is, do you think that in this case, based on what we've talked about, does the vulnerable adult have a claim against the emergency room doctor? And what does that claim look like? And if we had a live audience, we could field that, see if we get any questions that pop up here. Okay, we do have a couple folks. Maybe yes. We have a depends. We have another depends.
Depends is always a good answer.
Depends is good, yeah, depends. And I wish we could make it live, but we can't. So we will jump on to the next slide and talk about what happened here with the case. So does the vulnerable adult have a claim? And the claim here was medical malpractice. Now, think about that. The physician treated the injury and sent the patient on their way, but was ultimately sued in a claim for medical malpractice, which is in part strategic, by the way, to bring in the insurance carrier and to bring in the hospital, probably for the emergency room as for vicarious liability. And so medical malpractice suit against the physician for failing to report the suspected abuse. The physician had argued the confidentiality issue, that they couldn't disclose confidential patient information. And the court overruled the reporting, the court ruled that the reporting requirement for reporting abuse outweighed the confidentiality statute, and also noted that that statute provided immunity from civil and criminal liability for disclosure. And therefore, the court ruled that having failed to make the required report, the physician could be civilly liable in damages for injuries suffered from the continued abuse by the caretaker. So not for that injury and not for any complications that arose out of that injury, but when the physician allowed that vulnerable adult to go back to the caretakers who continued the abuse without taking advantage of the opportunity to step in and stop the abuse, the physician is now found to have committed medical malpractice. All the bad press, the reporting requirements that go with malpractice claims, that now goes on your national reporting record, and you also probably have a claim against the hospital, potential punitive damages, and all these issues that arose. This is an old case. This is, as I said, we took a little bit of liberty with this case, changed the facts. It's a 1976 case out of California. And we note here that although this is a California case, and the vulnerable, actually I said vulnerable adult, we probably should put VP here, vulnerable person. In this case, the vulnerable person was a child. But if you think about the circumstances of caretakers bringing somebody into the emergency room who is suffering injuries under the care, or at the hands of the caretakers, and that person is released back into the custody of the caretakers, we believe that similar principles are at work that align this case with the requirements of the statutory amendments to 415.1034. And so this is one example, a very old case. I'm certain there are other ones out there, but this is one that was reported in California. And somebody could take this case, combine it with the Ginder case, and again, argue here that with a bank, there is no real, the only duty is the duty that arises under the statute. But in Florida, with this requirement for our healthcare professionals, you have the ethical duty, the duty of care that goes along with your treatment of the patient generally, that also is buttressed by the statutory requirements and the language in the statute that I think creates additional exposure for a potential malpractice claim. So here we have the question, is the failure to report abuse grounds for a malpractice claim here in Florida? That remains to be seen. We don't know if that is the case or not, but I suspect that we're going to see that claim. And anybody who's ever been sued in a lawsuit, you know how stressful, hopefully none of our audience has, but it's very stressful. And you don't want to be a defendant in a case, even if it's a case that you are confident that you can win. And you don't want to be in that, like Teresa said, you don't want that press, you don't want all the negativity that would come with a case like that.
Yeah, you don't want to be on the Orlando Sentinel pages for that.
And we will see that. And if this is a strong public policy issue in Florida to protect our vulnerable population, to protect our elderly population. So here's our advice for healthcare professionals to ensure compliance. One, know the law. So for those who work with folks in the healthcare community, please share this information, share the statutory language. Feel free to share this information, the written materials that we've circulated today, the phone numbers and the information for reporting, which appears on the next slides. Know what to look for as far as signs of abuse and neglect or exploitation. Teresa deals with these issues in a lot of different contexts. In healthcare, it's, we have some obvious issues, but what about some less obvious ones that people may not realize?
I do. I mean, obviously physical abuse, you sometimes have the advantages of things like bruises and things that are going to show up in an examination, but sometimes neglect and exploitation are a little harder. Neglect being, it could be that, they're not, they're malnourished, and you may just think it's because they don't have an appetite, but it may be a caregiver using food as to control someone. And then financial exploitation is a little bit tougher to identify, and we talked about this probably a little bit more than most people about trying to how would you identify financial exploitation if your only relationship with that person is as a healthcare provider of some sort. I know when I come across these cases in my fiduciary work that I do, usually some of the signs is all of a sudden they're not paying their bills, their checks are bouncing. All of a sudden they won't talk to anybody. If anybody wants to be paid or get money from them, they'll tell you have to talk to my caregiver or my son. They won't be able to answer questions about how they're going to make payment and things like that, because all of that control has been stripped away from them. And they'll deny it in almost all cases. That doesn't mean it's not happening. It means that the people are taking advantage of the vulnerable person. They've convinced the vulnerable person that their life is better off that they're in it, and that it'll be worse if they're not in it. So they'll just allow the neglect and exploitation. And sometimes it's a pride thing, especially with older adults. They don't want to admit that they don't remember what happened, or they don't understand what happened, and that they didn't understand that they had given their checkbook to someone else in complete control. But I think get back to the point of what would be the signs that healthcare professionals would be looking for when it comes to financial exploitation. I think if there's any money issues that you or your staff become aware of, or if you ask, the person, how you're paying for today's visit, and they seem completely, lost and or completely direct you to deal with someone else as in a sense like they don't even know how to do that themselves. That might be some signs that you should pay attention.
And I also tend to think that if you have a long-term, it's one thing if you're an ER doc, or if you are an emergency medical provider in a limited circumstance, but if you have a long-time relationship with someone and you see patterns or habits start to change, you should at least start to question that. And you have some advantages in your capacity as a healthcare provider with some of these individuals, is that you can oftentimes figure out a mechanism to pull those folks off to the side if you have questions about it. And I think, as we've emphasized here today, if you have any questions and you're not sure whether or not you can get a clear answer to those questions, then you have a duty to report it if you have a question about it. And the question arises because of a good faith suspicion that you have, and that you'll be protected by reporting that.
Just put what made you suspicious. These are articulate exactly. Well, I saw this, or I asked this, and the answer was odd, or it was out of context, or out of the usual habit of this person.
Inquire about it, but you also let DCF do their job. And so they have investigators that are trained to know exactly what to look for and how to handle these situations. So let them do what they are trained and being paid to do. Finally, we put a note in here to make sure your insurance covers these issues. This statute is so new. Frankly, I wanted to get with a couple insurance professionals that I know ahead of time to see exactly how you get coverage for this. But certainly it's something that's on our radar now that I would be wanting my clients to have coverage for.
Especially if it was an employee that maybe
if you have
committed the error.
exactly. If you have folks working for you, employees, staff. Again, you can be a private practice physician, and your receptionist is aware of something and doesn't report it. Now you find yourself on the hook for that. We don't want to see that happen. So here's our wrap up.
This is my favorite part. So what was the purpose of doing this today and having this discussion and pointing out all this information? As I've alluded to before, I personally, in dealing with this work, I've seen a trend, and it's actually following throughout the country, of states and regional governments taking a more stringent approach when it comes to any kind of abuse and exploitation of the elderly. The financial exploitation has really come on as a problem, because the statistics, there's all kind of charts and statistics, and if you follow some of my other seminars on these kind of topics, or go back and look at them on our channels and on our website, you'll see I go through them in detail. The trends have been steadily going up. Now there's a combination of factors. One, the baby boomers have started retiring, so you have a bigger population. But there's also the trend has become so high, it doesn't account just for that. It seems to be more and more people feel, especially with the sophistication people have today, they feel more and more empowered to take advantage of people financially. And why does the state care so much? Why do regional agencies care so much? Because the cost to states and the cost to the taxpayers is actually in the billions. And there's reports that come out every year. Florida just recently commissioned a whole committee now that looks at these issues and reports back on what is costing the state and what are the numbers, what are the real numbers. Because a lot of these people are, by the time it comes to anybody's attention or the government's attention, the DCF's attention, these people have been left with nothing, and now it's the taxpayers' burden. So everybody, and what have people recognized, the people that have looked into this, what have they recognized? What can we do to stop the trend? Reporting seems to be universally one of those things that some of these committees and these professionals agree and make recommendations every year to the committees, legislature committees. We've got to encourage and require people to report, because if you can stop it in the early stages and punish the wrongdoer before they've skipped town and nobody can find them or left the jurisdiction, that's how we can maybe reverse these trends. So while I know it's common to think, well, the law is kind of not really, been too harmful to me if I haven't reported as a medical professional in the past, I don't think you can rely upon that anymore.
I think a judge there's a very good chance that that a judge, while you may have a circumstance where someone looks the other way, I think there's a very good chance that the judge here really puts the hammer to somebody when it's in a more egregious situation.
And I think the public policy is trending toward let the other third parties who've contributed to this by not complying with the law, let them pay for the harm that's been caused. If the wrongdoer is not available, let's not let the taxpayers do it. So when you put all that together, and you see these laws every year being tweaked to include more people or to make stronger consequences or to expand who they're applicable to, I think it's fair to see that the trend is going to be probably working toward third parties who include banks, financial advisors, and healthcare providers. One day they're going to look at them and say, you know what, you've got to contribute. At least a part of this could have been stopped if you'd reported it earlier. That's my guess where it's going. It's supported by the reports that I read, the data that I look at, and that certain agencies put out, and it just makes good legislative sense and good public policy if the goal is to try to start reversing these trends.
And again, not only for the folks who are joining us today, but for your folks who work in this industry and employees and staff, make sure you have good training in place. You don't want to run into an issue because somebody else didn't notice something, because a lot of times the professionals who are involved in a treatment are so deep in it, they don't notice all the other things that maybe a receptionist or an assistant picks up. And so we would encourage you to train your staff. And by the way, if you want help with that, or if you'd like us to present this to another audience, please let us know. We can do an abbreviated version of just what the requirements are, so folks are able to get their staff trained. Here's some information as far as where the reports go. Again, the phone number that we shared earlier, and also links to make a complaint using the online internet forums. Thank you for joining us today. Teresa, thank you.
Okay, thank you, Eric.
And everybody have a great rest of your day. Bye-bye.